cases come to court when Children and Youth Services files a petition alleging that your child or children are dependent. And what that means is that generally, Children and Youth Services can file a petition alleging several different grounds, but the most common ground that they petition upon is to say that your children are without proper parental care and control. It's important for you to also understand that not all cases come into court. Some cases, the families are able to be helped outside of court, but in this particular segment, we're discussing cases that have actually been made to come to court by the filing of a petition. The role of a judge in a dependency case is to hear all of the evidence that is presented and listen to it in an unbiased fashion and make sure that everyone is treated fairly in the courtroom and that the judge hears all sides and listens to everyone's opinion. Generally speaking, the judge will hear evidence from Children and Youth Services Agency. The judge will also hear evidence from the parents' attorneys and will also listen to evidence from the guardian ad litem and from the child. After considering all of that evidence, including any exhibits or any other documents or any other witnesses that are presented, the judge will then be making a decision in accordance with what particular type of hearing that they're hearing at that time. The role of a parent in a court hearing is to participate. You want to work with your attorney to make sure that your voice is heard in court. Judges make the best decisions when we get to hear what parents have to say, and you do that by working with your attorney to be prepared and make sure that any issues that you have are brought before the court.
The hearings don't always last very long, so sometimes you have a very short amount of time to get all the information in front of the judge that he or she is going to need to make the decision. So it's really important that you talk with your lawyer ahead of the hearing and make a game plan. What do we want the judge to know?
An important tip I would have for parents is that they want to make sure that they've reached out and their attorneys had the opportunity to sit down with them and have a detailed conversation about the plan for a particular court hearing. It's also important that you get to your court hearing early, because that affords you the opportunity to talk to your attorney and let them know of any last-minute surprises or developments, hand over paperwork you may have accumulated to demonstrate your progress. So there's no substitute for being there, and being there early is always a safe and smart thing to do.
In the courtroom, you will see other participants as well as the judge. You will see the Children and Youth Services solicitor, which is really a big word to say, but that's the attorney that represents Children and Youth Services. That attorney will generally be asking questions of the Children and Youth Services caseworker. You will also see the Children and Youth caseworker and possibly their supervisor in the courtroom as well. Also in the courtroom, you will see a guardian ad litem. The guardian ad litem's role is to represent your child or children. They are to tell the court what is in the best interest of the child and also what the child wants. In certain circumstances, there can be another attorney that represents just the child's interests to the court. Also in the courtroom will be a parent's attorney. If there are more than one parent, there may be multiple parents' attorneys, in that each parent would be entitled to have representation that represents their particular interest in court. It's important for you to know, if you cannot afford counsel, that you are entitled to have an attorney appointed to you free of charge so that your interests may be represented. You also may see in the back of the courtroom or in another location what is called a court-appointed special advocate, or a CASA worker. The CASA worker generally is appointed by the court to try to ascertain facts to help the court make a decision. You should also know that generally speaking, the hearings are not open to the public. If you see other participants in the courtroom other than what we've just discussed, and you don't recognize who that person is, you can discuss it with your counsel to make sure that only appropriate parties are in the courtroom.
My role as a master is I'll hear various cases involving shelter care hearings, adjudicatory hearings, dispositional hearings. There is a distinction between a master and a judge. A judge is an elected official where masters are not. Masters are employees, or in some instances, independent contractors that work for court administration.
Hearings typically start with the oath, and that's everybody's promise to the court that they're going to tell the truth to the court. The next thing that happens is the agency's attorney begins his case. And so they start by asking the Children and Youth Agency worker about what the issues in the case are. And then after the Children and Youth Agency worker testifies, everybody gets a chance to cross-examine. And cross-examination is where the attorneys for the other parties in the courtroom get to ask questions about what the agency worker just said. After that, a parent attorney will then have a decision about whether they need to put on evidence. Sometimes the parent attorney may decide, I just want to cross-examine the children and youth worker, but sometimes they may decide, I need to call some witnesses here. So they may call you, mom or dad, to testify to the court, or they may call other people who they think have important information that the judge needs to know. After all the parties have a chance to put on their testimony, the judge will make the decision.
I made sure I arrived to court on time, dressed appropriately, and the most important thing is I kept my cool. I didn't get upset. There were some times when I wanted to, but I depended on my advocate to, sometimes she said, we're okay, we're doing good, even though I thought that we were doing horribly, but I trusted her. And so I did everything possible. Like I said, I didn't cuss at anybody, I didn't roll my eyes, I didn't get an attitude, and I let my case speak for itself.
How you conduct yourself in court is really important. The judge is going to be watching the demeanor of everybody in the courtroom, and so it's really important to show the judge that you can stay calm and respectful throughout the case. Now, that is not always easy. Sometimes you're going to hear things as a parent that make you really upset. Court is inherently stressful, and sometimes it can get really upsetting and really stressful when you're in the courtroom. The most important thing to remember, and the thing I tell my clients before we go in the courtroom, is that you can control your own behavior and nobody else's.
The hearing officer or master at the conclusion of a hearing makes a recommendation. That recommendation, the desire of the hearing officer or master is to have that recommendation immediately following the hearing. Oftentimes it's impractical. Maybe there's a protracted, which means a lengthy hearing that can go for 2 hours, 3 hours. Sometimes a hearing can carry over to another day. So oftentimes it's impractical to have that recommendation out the same day. But the goal, the desire, is to make sure that a parent, a child, parties involved have that recommended order by the master or hearing officer the same day. So there are several types of hearings that a master or hearing officer or judge will hear. The first is a shelter care hearing. Shelter care hearing is also known as a 72-hour hearing. This type of hearing is critical because a child is taken into protective custody. And it's at this hearing where a judge, master, or hearing officer has to determine what's going to happen with the child, who's the child going to remain with until there is an adjudicatory hearing.
At an adjudicatory hearing, the judge is trying to decide whether the Children and Youth Agency has enough evidence to prove by clear and convincing evidence that your children haven't been provided with proper care by you. If the answer is yes, then the judge will adjudicate your children dependent. If the answer is no, then the judge will dismiss your case. Another type of hearing is a disposition hearing. This is often held directly after the adjudication hearing and may even be held at the same time as the adjudication hearing. At the disposition hearing, the judge is making a decision, what next? He makes decisions about what happens to your child. Can your child stay at home, or does your child need to stay in placement? He'll make decisions about what services your family needs, and he'll make decisions about what is in your child's best interest for the next few months.
The fourth type of hearing that occurs between a master hearing officer or judge is the initial permanency review hearing. It's at that hearing that the expectation is that the parents come prepared, again, with names of relatives, supports, all contacts that may not be a party to the proceeding, but can be a helpmate or an aid to the family. At this particular hearing, the judge or hearing officer will listen to evidence and make a determination as to whether the parent has made some sort of progress into alleviating whatever circumstances that brought them into the court. The judge or hearing officer will also be listening to see how compliant that parent is with whatever the prior recommendations were from the adjudicatory hearing. While it is the goal at all times for the court to reunify successfully the child or children with his or her particular parents, after 15 to 22 months, the agency must file for termination of parental rights.
Whatever the court recommends, do it. Don't get upset, don't fight it. I found that going to parenting classes from the perspective of a parent who is needy was very rewarding, to the point where I went, graduated, kept going back. And like I said, I didn't miss a single appointment. So the major thing for permanency is to do what the court expects. In fact, it wouldn't hurt to go above and beyond, because what I started to do, I actually sought out other groups I can go to. And that actually got into the court transcripts, and it looked very favorably for my part.